Hello everyone and welcome back to the channel. This is episode 7, our final episode of Flex Your Vote, where we will be breaking down Proposition 1 on the 2022 California ballot. And I realize that Proposition 1 is the first measure on our 2022 ballot, but I wanted to save it for last. It is a proposition that is near and dear to my heart, that involves so many interesting facets of the law and also ties in very timely and relevant legal significance with the very recent decision by the United States Supreme Court in Dobbs versus Mississippi this summer. So Proposition 1 was introduced in direct response to the United States Supreme Court's holding in Dobbs versus Mississippi, which essentially removed any federally recognized right to reproductive freedom. So Proposition 1 would seek to enshrine reproductive freedom in the California state constitution. It is currently not explicitly defined. However, it has been recognized by the California Supreme Court and is rooted in our privacy interest that is enumerated in Article 1, Section 1 of the California State Constitution. So some exciting law and background to dig into. And for those of you who are new to the video series, welcome. It's great to have you. Please catch up on episodes 1 through 6 and then join us back here for the final episode of the series. In episode 1, we introduce the video series, discuss how a measure makes it onto the California ballot, and also discuss the distinction between a referendum and an initiative, which is relevant for episode 6 and our discussion of Proposition 31. And episodes 2 through 6 cover all the other propositions on our 2022 California ballot. So check those out and then join us back here. And for those of you who are continuing on this journey with me, thank you for being a part of Flex Your Vote and being here till the very end. I hope it has been an engaging, informative, and empowering resource for you as you start to put together your ballot. This video series has been a passion project of mine and something that I've wanted to do for a very long time and finally gained the confidence and the motivation to make it happen. I believe that, like I said in my very first episode, the power of our vote is at its highest point when we cast an informed ballot. So whether it has been gathering the right information through this video series or other supplemental resources like Cal Matters and California Choices, I hope that you have been doing exactly that, trying to prepare an informed ballot. And note that Election Day is coming up. It is a week from today. So please be ready to vote because your vote matters. So, with all of that and so much gratitude, let's jump right into our final episode, episode 7. So our discussion of Proposition 1 will bring together various aspects of our federal and our California state law. But I promise we are going to put this puzzle together. We will be discussing both the United States Constitution, specifically the Due Process Clause of the 14th Amendment, and the California State Constitution, specifically Article 1, Section 1. We will also be touching on one California state statute, Health and Welfare Code, Section 123460, also known as the California Reproductive Privacy Act of 2002. And we will also be discussing 3 different cases, 1 federal case and 2 California state cases. The federal case is, of course, Roe versus Wade, decided by the United States Supreme Court in 1973. And the 2 California state cases will be People v. Belos, decided by the California Supreme Court in 1969, and conservatorship of Valerie N., decided by the California Supreme Court in 1985. I realize that is a lot of varied law, but all critical to our understanding of the outlook of reproductive rights in the state of California and critical to our discussion of Proposition 1. Okay, so let's begin with the language of Article 1, Section 1 of the California State Constitution, which provides that all California constituents have a fundamental right to pursue and obtain safety, happiness, and privacy. That is a general text enumerating a fundamental right, and so our California Supreme Court was entrusted with interpreting what specific rights are included per the language of Article 1, Section 1 of the California State Constitution. Now, in 1969, the California Supreme Court first held and recognized in the case People v. Belos that this right to pursue and obtain ... privacy extended to a fundamental right to terminate one's pregnancy. It wasn't explicitly stated in the holding of the case, but the California Supreme Court did recognize that the right to privacy extended to reproductive rights. Now, in 1985, the California Supreme Court further clarified in conservatorship of Valerie N. what this right to privacy entailed, that it not only extended to a fundamental right to terminate one's pregnancy, but also a fundamental right to contraception. So with those two California state cases put together, the California Supreme Court has recognized as of 1969 and 1985 that the right to privacy per the text of the California Constitution extends to the right to terminate one's pregnancy, abortion, and the right to contraception. And that both of these rights are included in the reproductive rights extended to individuals in the state of California. Okay, so that is the lay of the land in California. What exactly is the lay of the land under our federal rights? So this now moves our discussion to the United States Constitution, specifically the Due Process Clause of the 14th Amendment, which directs that no state shall deprive any individual of life, liberty, or property without due process of the law. And this liberty interest, housed within the Due Process Clause of the 14th Amendment, is the bedrock of our right to privacy. This right to privacy has been recognized to extend to our right to marry who we wish to marry, in cases like Obergefell and Loving, our parental rights in the case of Stanley versus Illinois, and our right to abortion, housed within Roe versus Wade and Casey versus Planned Parenthood. But we're going to focus on Roe versus Wade. Now, Roe versus Wade was decided by the United States Supreme Court in 1973 and recognized that within this right to privacy of the Due Process Clause of the 14th Amendment, individuals had a right to abortion delineated by trimester. Within the first trimester, the court held that states are prohibited from restricting abortion, and that abortion was left up to the decision-making of the expecting woman, the pregnant individual, and her attending physician. That within the second trimester, the court held a state may impose a restriction so long that the restriction is reasonably related to maternal health. And within the third trimester, when a fetus is understood to reach the point of viability, meaning a fetus is able to exist outside of the womb, a state is permitted to further restrict or even prohibit altogether abortion so long that there are exceptions for the health of the mother. That was the holding of Roe versus Wade, and the case which first recognized on the federal level a right to abortion. Now, this right, of course, has seen many iterations. It was impacted by the Supreme Court's holding in Casey versus Planned Parenthood, and of course, most recently in the Supreme Court's ruling in Dobbs versus Mississippi this past summer. Now, with the court's ruling in Dobbs versus Mississippi, there is no longer a federally recognized right to abortion housed within this right to privacy of the 14th Amendment Due Process Clause. Instead, now states are free to construct their own laws and their own restrictions on abortion, and there is no federally recognized right that will regulate a state's response and a state's law in regards to abortion. So that is where we are today with all the iterations of the law in California and on the federal level. In 2002, however, California did take an affirmative step to further define reproductive rights in the state of California under the Health and Welfare Code Section 123460, also known as the California Reproductive Privacy Act. This act was passed in 2002 and explicitly defined a right per the statute. So this is not to be confused with the language of our California state constitution, but per statute and this Health and Welfare Code, individuals in California would have a right to terminate their pregnancy and would have a right to contraception. This is statutory language, and there is an important consideration in this statutory language that this right to abortion only extends to the point of viability. After a fetus is viable, an individual in California is not permitted to willy-nilly abort the fetus. So there are restrictions on abortion per California statutory law, per this Reproductive Privacy Act, that until the point of viability, there is this right to abortion. However, after viability, abortion is only permitted if there is considerations for the health and safety of the mother. That statutory language is important to keep in mind because it very much informs the future of reproductive rights in California, even if Proposition 1 were to be passed. Okay, so we've talked about the California landscape, the federal landscape, and this Reproductive Privacy Act, this statutory law in California. Where does Proposition 1 fall into this mix? So Proposition 1 would enshrine a constitutional right to abortion and a constitutional right to contraception. This is distinct from the current Health and Welfare Code Section 123460 because that code is a statute. And the legislature, let's say the makeup of the legislature changes in the next election or an election after that, the legislature is permitted to amend the statute. So let's say that we have a different political layout in our legislature in California. They would be permitted to amend the language of this Health and Welfare Code. Of course, they cannot interfere with the court's interpretation of the California Constitution. So there are a few protectors of reproductive rights currently in place in California. But the concern is that what happened on the federal level could effectively happen on the state level. And having a certain makeup of individuals and certain philosophies in positions of power, as we saw on our United States Supreme Court, should and could, not should, only could, fundamentally alter interpretation of the law. That's what happened on the federal level, that an increase of conservative values and conservative appointees changed the makeup of the United States Supreme Court and led to Dobbs versus Mississippi. Theoretically, that could happen in California as well. That could happen in our legislature, and that legislature could amend this Health and Welfare Code, Section 123460. This could also happen in our makeup of the California Supreme Court, and they could amend cases like People v. Belos and conservatorship of Valerie N. And that would change our understanding of what this privacy right in California would include. So let's talk money and let's discuss the arguments for and against. To date, there has been a total of $13 million invested into this race. Supporters have invested $11.8 million, while opponents of Proposition 1 have invested $1.2 million. Supporters emphasize that enshrining a fundamental right to terminate one's pregnancy and a fundamental right to contraception in the California state constitution will protect reproductive freedom from any changes in legal interpretation of the law. And this directly implicates the changes in legal interpretation that we observed on a federal level with the United States Supreme Court's ruling in Dobbs versus Mississippi this past summer. Supporters of Proposition 1 also emphasize that while the language of enshrining a fundamental right to abortion and contraception is broad, it will not affect the restrictions that we have on late-term abortion. So although the language of this inclusion would be broad and protective on its face, it would not be this kind of pathway to now allowing late-term abortions in the state of California. Of course, on the flip side, opponents of Proposition 1 really emphasize this latter fact, and that's the basis of their argument, that because the language of Proposition 1 is broad and ambiguous, it would now contradict Health and Welfare Code Section 123460 and allow possibly abortions after the point of viability. Important to consider that this is simply an argument by the opposition and is not a concrete fact. Opponents to Proposition 1 also suggest that including this fundamental right in the California state constitution is redundant because we already have the court's interpretation of right to privacy per our Article 1, Section 1, and this statute, the Health and Welfare Code, Section 123460, which both together protect the right to abortion and the right to contraception in the state of California. So there is no need to enshrine this right in the Constitution. Another argument by the opposition is that because the text to be now included in the Constitution would be broad, it would lead to years and years of litigation in the courts to really pinpoint what this new language would include. And litigation is costly, it is time consuming, and it can be very confusing for providers, for childbearing women, and for all individuals in the state of California. And that confusion is something we can avoid by voting no on Proposition 1. So those are the arguments for and against. I realize that these type of topics and these policy considerations can be very intimate and personal. So I encourage you to do as much research on this proposition as you need to feel confident in whatever vote you choose to cast. But also consider your values and your moral concerns, those are very valid in interpreting your approach to Proposition 1. So please know that your decision making is valid in terms of this proposition. I realize it might be complicated and challenging, but I hope this video has been informative and helpful. With that, we are a wrap for the Flex Your Vote video series. I have really enjoyed this entire journey with all of you and engaging so deeply in our 2022 propositions. I would love to hear from you. Please include some comments and questions down below. And remember to vote a week from today. And with that, I am signing off for Flex Your Vote. Thank you all for being a part of it.